City Commission meeting to order at 4 p.m. All commissioners are present. Any consideration of the minutes?
No changes.
I've considered them,
And
they're in good shape.
thank you very much.
Me too.
Appreciate that. We have a room full. Any citizen comments?
Anybody?
Comment.
Somebody? Anybody?
We have nothing on the consent agenda. We'll move right into all this exciting stuff. Ordinance authorizing the city to issue general obligation bonds, Series 2024A, to fund an economic development grant. Mr. Rupp.
Good afternoon, Commissioners. Kim Rupp, Director of Finance. This is probably a record number of resolutions for you in one meeting. Bear with us. I guess it only means that we're doing very important things.
Right.
So I'm here to speak to you about the next set of documents we'll need approved to continue with the issuance of general obligation bonds 2024A to fund the Economic Development Grant in connection with the Tallgrass Second Edition. With me by phone is David Arterberry with Stifel Nicholas to report on today's results of the bond sale. We received a AA rating from S&P on this bond issue, which is a very good rating for our city our size. And David will go over a little about how that translates into the results you see today from the bids. These next two slides you have at your places also. If you can't see those, they're available to you. So David, if you could continue, please.
Sure. Can everyone hear me all right?
Yes.
Yeah, sounds great.
Okay, good. Yeah, as Kim was saying, the city took bids today on both the $2.6 million of general obligation bonds to fund the RHID grant, and then $3.6 million of general obligation temporary notes to fund the water meter acquisitions. The agenda items that you have in front of you address both of the bonds and the notes, and so rather than do it separately, if it's okay with you, I'll just kind of talk in generalities about how both of the sales went together. As Kim was mentioning, the city did get its bond rating reaffirmed by Standard & Poor's at the AA level, and that is an excellent rating. It's the highest rating that I'm aware of that Standard & Poor's gives to any city that's not located in a metro area in Kansas. And it also is, they also rated the temporary notes, which they assigned a little different rating because it's a short-term debt. They assigned it their highest rating of S&P 1+. Both Kim and Toby and Colin all did a very nice job presenting the city and its credit to the rating agency. So we got that rating about 2 weeks or so ago, and then about a week ago, the preliminary official statement, the offering document, as well as the notice of sale, the bidding documents, were distributed to potential bidders around the country, as well as the sale was advertised on Bloomberg and in the Bond Buyer, which is a daily municipal bond newspaper. All this led up to the sale of the bonds and notes occurring today. We received bids at 10 a.m. for the bond issue, and for the bond sale, we received a total of 9 bids, which was an excellent response. Honestly, on an issue of this size, about $2.6 million, I would normally expect somewhere between 4 and 6 bids. So getting 9 bids was great. The best bid on the bonds was submitted by Country Club Bank, and their interest rate was 2.70560%.
Dave, 3.7?
3.7.
Oh, yeah, I'm sorry. Yes, 3.70560%, to be exact.
We like the other one better.
Yeah, we'll hold you the way you said the first time.
Yeah, 3.7. So I apologize. The bids for the notes were opened after that, and the best bid for the notes was submitted by Piper Jaffray, and they offered a rate of 3.347 4.59%. The reason the note rate is lower is that the bonds were being sold over a 21-year period, repaid over 21 years, whereas the notes are just a 1-year obligation. Both bids were reviewed for accuracy and that they met the bidding parameters, and they both did. The best bid by Country Club Bank, statutes require them to provide a good faith deposit equal to about $53,000, and Country Club provided that. So everything went very well. I was real pleased with the results of the bidding. I think a lot of the reason the bidding was so strong was number one, the AA rating. That goes a long way towards attracting bids for the bonds, and then the S&P 1 Plus rating, attracted the bids for the notes. And the other thing I think that also came into play here is that the bonds and the notes are both considered bank qualified, which is a designation under the tax code that issuers who are selling less than $10 million of debt can get on their bonds, and it makes them especially attractive to be purchased by banks. So those two factors, I think, led to the real good bidding results that you got. So, the only action items remaining as far as the commission is concerned then is to adopt the bond ordinance, the bond resolution, and the temporary note resolution that will officially authorize the issuance of the bonds and notes and lock in these interest rates. I would also mention one other item related to the bonds. When the bonds were bid on, it's very common that purchasers or bidders, along with paying for the principal amount of the bonds, will bid with a premium. And in this case, that, as normally happens, with the bonds, Country Club Bank bid a premium. As a result, since that premium was not needed to pay project costs, we ended up using that premium to reduce the size of the issue. So originally we anticipated the issue would be $2,660,000, and as a result of the final resizing of the issue, utilizing that premium, the total principal amount of the bond issue ended up dropping to $2,520,000. So that's why you'll see a little bit different number on the documents than you originally adopted when you authorized the sale. So, it covered a lot of ground here. So obviously I welcome any questions you might have about the rating, the process we went through, the bidding, the market.
Commissioners? They're pretty quiet.
It was well done, pretty self-explanatory. And when you get the best ratings possible, there's not a lot of questions like, why didn't we get a better rating? We were there, so I think when you get the lowest rates possible and the highest rating, I think you've nothing to do but be pleased.
Pricing's pretty good.
So going on then with the ordinance, the city previously approved an economic development grant to Heart of America Development Corporation in the amount of the $2,565,000 related to the Tallgrass Second Edition. That's the RHID project. The city also authorized the sale of its general obligation bond, Series 24A, in order to finance the funding of the grant. The bond ordinance and the resolution will authorize the city to issue the bonds to fund the grant. The ordinance is first. It authorizes the bonds be issued to pay the cost of the improvements, allows us to levy for debt service, and directs city officials and staff to execute the necessary documents to complete placement. We have obtained an addendum to the original development agreement that assigns the RHID revenue in the Tallgrass to the city, and the intention of using that for debt service on 2024A. And while projections on the RHID revenue are well within parameters to serve the debt service, it is noteworthy to note that if for some unforeseen reason that revenue falls short, given this is a general obligation of the city, documents do give us the ability to levy if we absolutely have to for debt service. So on this, two options approve the ordinance or provide us with other direction. And this would be my action requested on the ordinance.
I move to approve ordinance number 4063, authorizing the city to issue general obligation bonds, Series 2024-A, to fund an economic development grant.
Second.
Been moved by Commissioner Reuter, seconded by Commissioner Cunningham. Is there any further discussions, questions, comments? Not, I'll call for the vote. All in favor, please say aye.
Aye.
Opposed, same sign. Pass 5-0. Next, the resolution setting forth the form and details of the General Obligation Bond Series 2024A.
So the resolution is a detail of the bonds, including redemption, security, establishment of funds and accounts, application of bond proceeds, defaults and remedies, continuing disclosure, and other miscellaneous provisions. While it's a very lengthy document, it is pretty straightforward and also allows us to fill in the blanks, if you will, that we have results from the, as we have results of the sale of the bonds now. We would ask approval or provide us with other direction, and this is my action requested on the resolution.
I move to approve resolution number 2024-027, prescribing the form and details of the city's general obligation bonds, Series 2024-A.
Second.
Moved by Commissioner Barrick, seconded by Commissioner Musil. Any further discussion, comments? Not, I'll call for a vote. All in favor, please say aye.
Aye.
Opposed, same sign. Passes 5-0. Resolution authorizing the city to issue general obligation temporary notes, Series 2024-1, to finance the advanced metering infrastructure.
The city previously approved a project to install advanced metering infrastructure for the city's public water system. City also authorized the sale of general obligation temporary notes, Series 2024-1, the notes, in the amount of $3.6 million in order to temporarily finance a portion of the cost of the AMI project. Once again, David will go over results today on the sale of the temporary notes, and we talked about that 1+ rating, which is the best you can get on notes. So, David, I have the results of these bids up if you wanted to add any more to that.
No, again, the best bid was submitted by Piper Sandler, and the interest rates for the bid are shown there, and it was verified. It was mathematically correct, and it was a nice bid.
So state statute does not require an ordinance for issuance of temporary notes. We go straight to the resolution, basically the same as a 24A. The bond, including redemption, security, establish of funds, and so on, continuing disclosure, and those other miscellaneous provisions. It is our intention to issue permanent financing at the end of the AMI project. Should there be anything left from these notes, we will apply that and then finance what we have to at the end. So it's possible that we'd be in under the 3.6. So we'll see how that plays out. A couple of options again: approve the resolution or provide us with other direction, and this would be my action requested.
I move to approve resolution number 2024-028, authorizing the city issuance and prescribing the form and details of the city's general obligation temporary notes, Series 2024-1, to temporarily finance a portion of the advanced metering infrastructure.
Second.
Been moved by Commissioner Cunningham, seconded by Commissioner Barrick. Comments, questions? Not, a call for a vote. All in favor, please say aye.
Aye.
Opposed, same sign.
David, if you could hang with me just a little bit longer.
Pass 5-0.
Yeah, certainly.
Okay, the resolution authorizing a public building project, Police Department building.
The city has identified the need to construct a new police station and municipal court facility at an approximate cost of $8.9 million. And in order to establish the ability to finance all or a portion of the cost of the new facility through the issuance of general obligation bonds and temporary notes, the project must be authorized by resolution. The project authorization resolution pursuant to state law. City plans to finance approximately $1.39 million of the cost through a taxable general obligation temporary note issuance, where the city would also act as the temporary note purchaser. These temporary notes will be authorized by resolution and retired from amounts currently available in the city's bond and interest fund. The Approval of the project authorization resolution does not bind the city to construct the project, but instead establishes the ability of the city to finance the project through the issuance of these bonds and temporary notes. It allows the city to erect, construct, acquire, alter, remodel, furnish, and equip public buildings. It also allows the city to reimburse itself then for the cost of the building with the temporary notes. The project authorization resolution is first, so either approve or provide us with other direction, and this is our action on the resolution.
Make a motion to approve resolution number 2024-029, authorizing a public building project.
Second.
Been moved by Commissioner Musil, seconded by Commissioner Reuter. You picked the short one.
I was going to say, he took the short one.
I've learned.
If there's no other questions, I'll call for a vote. All in favor, please say aye.
Aye.
Opposed, same sign. Passes 5-0. We're just clipping right along here, Kim. Resolution authorizing the issuance of the city's taxable general obligation temporary note series 2024-2.
Approval of the temporary note resolution authorizes, so what you just did, authorizes the city to issue its taxable general obligation temporary note series 2024-2 in the amount of just shy of $1.4 million in order to pay a portion of the cost of the project we talked about for PD and courts. The Series 24-2 notes will be purchased by the city as an investment and will be retired from amounts currently available in the bond and interest fund. City's purchase of its own notes saves the cost of issuance that we would otherwise have if we sold to a third-party purchaser. Approval of the taxable temporary note resolution will result in an issuance of general obligation debt of the city. Series 24-2 notes are not expected to remain outstanding or be refinanced beyond the contemplated December 24 maturity date. These notes are a financing of the beginning stages of this project. When we were budgeting for 2024, we worked these temporary notes into the bond and interest levy fund, as we knew there'd be some costs up front and that we would need to pay, and significantly. It was mentioned last week at the work session that this does not raise the levy, nor does it incur more debt at this time, as we had budgeted this into the bond and interest levy for 24. And since we're buying our own bonds, they'll be paid off with those funds out of the bond and interest the day after closing. David, is there anything you want to cover here in the structure of this, since it's a little different type of financing?
No, I guess the only thing I would mention that, by doing this, the city will essentially be able to take the money that right now is in the bond and interest fund and can only be used to pay debt service on general obligation bonds, and essentially free it up and make it available then to use to pay some of those initial project costs. The reason the temporary notes are designated as taxable simply is because the federal tax code says that if a municipality is buying its own debt, its own bonds, that they're not eligible to be tax-exempt bonds. In this case, that really doesn't make a difference, because the interest that is going to be paid by the city will also be received by the city in the form of investment income.
Makes sense.
So state statute, again, doesn't require an ordinance for the issuance of temporary notes. Going straight to that resolution, the very same thing: establishment of funds, application of bond proceeds, defaults and revenues, and allowing us to fill in the blanks. It is our intention to issue permanent financing at the end of this project. Given this is treated as an investment of the city, these will have a rate equal to our money market investment account. It will be 1 day's worth of interest, as he talked about, be able to pull available funds from the bond and interest fund that we budgeted in 24 and immediately retire these the day after closing. Approve this resolution or provide us with other direction, and we ask for approval of this resolution.
I move to approve resolution number 2024-030, authorizing the issuance of the city's taxable general obligation temporary notes, series 2024-2.
Second.
Been moved by Commissioner Reuter, seconded by Commissioner Cunningham. Discussion, questions, comments?
Only thing I would say is, we're able to get these ratings because of the way we've you guys have managed our money for many years. Toby, your staff has done a great job, and our board has done a great job, and that's why we can do what we're doing with the bonds, and hopefully we can continue the ratings and keep doing the projects we're doing and be fiscally responsible with the money we're using.
And we save money by doing clever accounting, which is very
That's right.
different, I
Clever
understand, from
accounts, good.
creative accounting, which is something we don't want to get into.
Let's not do that.
I want to appreciate the
Clever.
very clever accounting.
Very clever.
I like that.
Anybody else? Not, I'll call for a vote. All in favor, please say aye.
Aye.
Opposed, same sign. Passes 5-0.
Thank you all very much. David, thank you.
Yep, thank you, everyone. Have a good evening.
Thank you, Kim. Resolution to call public hearing on establishment of Community Improvement District, a CID, for the SERVS project.
Good afternoon, Jared Kuckelman, Management Analyst. So today we're talking about incentives for an economic development project for SERVS, including a Community Improvement District, or CID, and Industrial Revenue Bonds, or IRBs. Just some background. Most of us, and I'm sure many of the citizens of Hayes, are quite familiar with SERVS, as they currently operate 4 convenience store and gas station locations throughout Hayes, as well as 2 others in other communities. This does include the location at 3701 Vine Street, which is the subject of this project. SERVS, the developer, is seeking to construct a new store building and gas station facility in a newly reconfigured and improved site layout. As part of the project, the developer has requested a 1.5% CID and IRB sales tax exemptions on materials. So here's an image showing the location of the site being discussed. It's right off Vine Street, just to the south of the interstate. And just to be clear, this is not the 27th and Vine location, nor is it Hall Street or Main Street. This is 37th and Vine Street in North Hayes, just to the south of the interstate. So here's some images showing the site as it looks now with the current convenience store building and gas station. Here's a site plan that shows how the site configuration could change under the proposed redevelopment. The convenience store building would shift in location to the north side of the lot. For some reason this is pointing at this screen. But north side of the lot, the entrance is facing south, and this proposed change instead of east like it currently does. The gas station pumps would then all be located on the south side of the lot. And my understanding is kind of that the idea behind these changes in the site layout is that it would facilitate some greater ease of vehicular and truck traffic in and out of the location, while the new store building would be larger, have an increase in square footage with some updated amenities that would be more attractive and inviting to travelers and visitors. So one of the incentives being asked for here is a CID. CIDs have been around in Kansas since 2009 to help cities promote business activity and economic development. CIDs are designed to be a special assessment and/or a special sales tax on retail sales up to a 2% max for no longer than 22 years. CIDs can be used by property owners to cover things like vertical construction, infrastructure, parking, land costs, professional fees, etc. These are not sales taxes that already exist. They are an additional sales tax on retail sales that's added only to the designated district/property. So not any other locations outside the district have the CID levied on them. Basically, it's something that the landowner or developer chooses to have imposed on themselves and their business to help reimburse for the items that I just mentioned. So while the maximum CID allowed by state statute is 2%, the applicant here is requesting a 1.5% CID. So on the financial side, this project is estimated to have project costs of $4.7 million, of which $3.2 million has been estimated to be eligible for CID reimbursement. However, the developer has estimated that the CID would generate approximately $895,000 for reimbursement over 22 years. And these numbers have been created based on the developer's financial projections. The developer is also seeking industrial revenue bonds, or IRBs, for the purposes of this project. Of the 2 possible incentives that IRBs can offer, this project is only eligible for and seeking the sales tax exemption on construction and remodel materials. As we've discussed before with some previous projects, IRBs are a unique bond issuance, so the city is really the pass-through vehicle and only the conduit issuer. This is maybe the first time we've talked about IRBs in the same meeting where we're also talking about general obligation or special obligation, temporary notes bonds, so it's just maybe worth highlighting.
We're just
for
covering it
these-
all.
Yeah, for these ones, IRBs do not affect the city's debt limit or rating, do not require taxpayer commitment, and the developer is solely responsible for the payment obligations. So based on the numbers provided by the developer, this is a table showing the dollar amounts provided by the incentives as a benefit. So as you can see, this is a pretty significant project. So the incentives really contribute about 21% of the total project costs. That leaves nearly 79% that is the responsibility of the developer. I will note, though, that the developer has also pursued and will be pursuing some other funding mechanisms, including the NRP, as well as some other grants and incentives that are out there. And I just bring this up to highlight that there are a lot of moving parts here that are coming together to help make this project a reality. So here's the calendar showing where we're at in the process as well as what the next steps are. This is basically the last step for the IRB's portion of the project, while today's action on the CID is a resolution to set a date for a public hearing. If that's approved, the CID public hearing would be held in November, along with final consideration of the CID ordinance and development agreement. So there's still a few more steps in the process before everything will be done and completed. So for financial consideration, the overall project has an investment of about $4.7 million. And once completed, the developer estimates it could generate annual retail sales of starting out at about $1.5 million in the first few years, and eventually getting up to $2.4 million. As was mentioned earlier, there is about $3.2 million in CID eligible costs, but the CID is expected to generate $895,000 over the 22-year period. On the bond side of things, only the IRBs are issued for this project, so no general obligation or special obligation bonds, and IRBs don't affect the city's debt limit or rating. So these are the options for you today for both the CID and the IRB. And these will be the actions requested for both items. It'll be a motion and a vote on each one, since they're separate actions.
I'll make a motion to, where are we at? You want to do the top one
Top
first?
one,
I'm assuming?
yeah.
Okay, I'm sorry. Make a motion to approve the petition forward by adopting resolution number 2024-031, setting a hearing date on the creation of the CID November 14th, 2024.
Second.
Moved by Commissioner Musil, seconded by Commissioner Reuter. All in favor, please say aye.
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 Opposed,
Aye.
same sign. Passes 5-0. I didn't think there was going to be comments or questions. The next one?
I move to adopt resolution number 2024-032, evidencing an intent to issue industrial revenue bonds for SERVs.
Second.
It's been moved by Commissioner Reuter, seconded by Commissioner Cunningham. Any questions, comments?
I have one, which probably should have went before, but it's okay. I'll ask now. The serves at all their, including all 4 locations, have they previously used a CID for any of the other renovations or upgrades they've done?
I'm not aware of any before.
Okay.
No.
Perfect. Thank you.
Did you have another one?
No, that's
One
it.
question.
Sorry.
Okay.
I'd just add, you know, if you go to any of his businesses in town, they're some of the cleanest, classiest businesses in town. He's invested for many years, and this business, it's kind of the doorstep of our community, and I think it's just going to add to the look and potentially bring more business, so I'm excited about it.
My comments from last week kind of go along with that. Continued investment in the community is appreciated by Russ and others of his family. It is an entrance to our community, and I think it's really going to be exciting to have it new and all that area a little, not that it isn't nice now, but it'll take it up one more step. So we appreciate it.
And I just think that it's, for me, it's very important and worthwhile just for the safety factor of how the entrance and exit of the vehicles there,
Yep.
as well as the factor of how it looks as an
Aesthetics,
entrance
yeah.
to the city. And it's interesting, I like math, so
Oh.
that all the big numbers up there turn into about $111 a day of taxes collected each day, which means about $7,400 worth of retail business done every day. I get to $2.7 million a year instead of 2.4.
Oh, I'm going to take your numbers.
But I think it's a well worthwhile project.
Certainly
to be
is.
do.
Yep.
Okay, all in favor, please say aye.
Aye.
Opposed,
Aye.
same sign. Passes 5-0. Thank you, Jared.
Thanks, Jared.
And Russ, thank you again. We appreciate everything you're doing.
Chris?
Um,
I think you guys just set a record for the most amount of behind-the-scenes paperwork created, in the least amount of time.
This is so exciting. For all we have
What
done.
she's going to have to sign.
I know, I thought you guys threw this real fast, so I want somebody else to sit here behind me and sign.
Great to be down here this week.
Okay, we have R9 updates. We'll start with Mr. Brown.
Good evening, Commissioners. John Brown, R9 Project Manager. And as I reported at our last update on the R9 project back in March, my work related to this project is focused on 5 areas: funding sources, survey, easement acquisition, wellfield design, and pipeline design. Listed here are the funding sources being pursued or considered. A few weeks ago, I was here before the Commission with a direct technical assistance MOU through FEMA's BRIC grant program. That program will help us to be more competitive in our resubmission of a BRIC federal project grant in early 2025. The FEMA team is actually scheduled to be on site on October 22nd to really get this portion of the project going. In August, we applied for $1 million from the Kansas Water Office Technical Assistance Fund to help pay for the cost of design engineering. We applied for this same program last year and we weren't selected. However, there is actually more money available this year, and so we gave it another shot. We plan on submitting another application to the Build Kansas, which would cover non-federal share of a BRIC grant or any other federal bipartisan infrastructure law program that we might receive for this project. WIFIA is a low-interest loan program through EPA that could be used to finance the balance of the project not covered by other means. We anticipate submitting a letter of interest later this year, early next year, to start the review process for this program. And the State Revolving Loan Fund, the SRF program, is still an option for the future. And finally, a revenue bond, it could be considered if interest rates are equitable to state and federal loan programs. Driggs Design Group has completed the boundary survey of the R9 property. An aerial survey of the entire ranch and the pipeline route was flown earlier this year. Driggs completed ground survey for 10 of the 11 segments of the pipeline route. The only portion left is here in Ellis County, around Shenshin area. And Burns McDonald has completed the environmental review and cultural resources study for the pipeline route, and no areas of significant concern were found. As mentioned in previous project updates, the pipeline route was selected last November, and in January we hired ORC to provide easement acquisition services. ORC has made notification to all property owners along the pipeline route. Ellis County Abstract has completed all the title work on proposed easement tracks. The surveyor and the engineer are working on the legal descriptions for the easement tracks, and they have about 30% of those complete. The city attorney's office has engaged in an appraisal firm to provide appraisals on properties that may require formal appraisals due to federal requirements or for other reasons. And all this activity is preparation of making offers to start purchasing easements later this year or early next. This map shows the potential municipal well locations labeled A through N, where test wells were drilled earlier in the year. In July, we held a workshop with our engineers to determine the wells that would be developed in this phase of construction. The map shows 7 well locations and the pipeline in blue that will be developed as part of this project. The green lines and locations in green would be constructed in future project down the road. A storage tank and pump station would be constructed in the general location of the blue square. See if I'm any better than Jared. Oh, there we go.
Nice going,
Also discussed at that July design workshop we had with the engineer was pipeline materials and sizing. We are moving forward with both PVC and ductile iron pipe material to keep a competitive bidding environment and hopefully to keep the largest cost of this construction, the pipe material costs, low. The pipe diameter will be dependent upon pipe material. Ductile iron would be a 20-inch pipe, while PVC would be a 24-inch pipe. And that's due to the ductile iron being able to handle higher pressures at a thinner wall thickness. As showed by the hydraulic grade line here in red, in order to pump the max allowable, the 6 million gallon per day from the R9, an intermediate pump station would be required in between the R9 ranch and the Smoky well field if we used a 20-inch line. If it used a 24-inch line, would not require an intermediate pump station. I would also mention this is for ultimate possibility of pumping the max allowable 6 million gallons per day. This project is not being designed. We're not going to develop enough wells to actually pump 6 million. So an intermediate pump station would be way down the road. So we are also analyzing the best scenario for storage tanks. On the previous slide where I did my pointer magic, I pointed out the location of a 500,000 gallon ground storage tank at the R9. We're also considering a 250,000 gallon elevated storage tank at the top of the hill just north of the Smoky Hill River by Shenshin. And that would help with the hydraulics of the whole project.
So John, there won't be one at the ranch, storage tank?
The one at the ranch would be more of the ground storage tank with a pump station. And then at the at Shenshin, just north of the river, up on the hill, we would have an elevated tank because we'll have the pressure in the line to fill an elevated tank, and then that would provide the pressure needed to get it to Hayes and Russell without a secondary pump station. If we put a ground storage tank, we'd be losing all that advantage of that pressure, and then we'd have to pump it again. So the elevated tank is economical or optimal in providing the best hydraulic.
I just clarified that this part of it is also included in the estimate. This isn't anything we're adding. That was the first thing when I haven't seen a picture like that, so uh-oh.
So those two things are comparable in
Right.
overall cost.
Right. The original plan had having to have a pump station there, and we can offset the price with the elevated storage tank by
Gotcha.
eliminating the pump station. So.
Interesting.
So in summary, the short-range schedule for well-field improvements includes Burns McDonnell finishing a basis of design report to be submitted to KDHE by the end of October. That's required by KDHE to proceed with this approval of the project or getting the permit to do the project. They would be beginning geotechnical investigations in November at the proposed well sites and the storage tank location at the R9, and then beginning 60% design drawings in December. The pipeline improvement schedule has 30% design drawings completed by the end of October, easement and legal documents in the November timeframe, and then offers for easement acquisition being made starting by the end of the year and continuing into 2025. All of these activities lead to entering contracts for construction in late 25 or early 26. So if you have any questions for me, I'd be happy to answer them now. Otherwise, I'll turn it over to Chris, and he'll give you an update on the operations of the ranch.
I just have a question about the two different types of pipe. Will there be benefits? I know you said the size matters based on the type of material, but is there a benefit long-term?
No, all the pipes are pretty much all designed for a 50-year life, which turns into a 100-year life. I mean, so we have, I guess the difference would be in horror stories about pipe failures now. Back prior to the 60s or 50s, a lot of the cast iron pipe was cast iron pipe and it wasn't lined. And some of that pipe is failing now. The ductile iron pipe that we use today is lined with cement, and so it doesn't fail as readily as the old cast iron lines. So the lifespan's pretty similar. You know, the jury is still out on PVC pipe because it's relatively new and it is a flexible pipe, so pressure changes and stuff, it will fatigue over time. We just know it will. We haven't found out when that is going to be. The ductile iron is a more of a rigid pipe. It doesn't have those dynamic forces acting upon it as the PVC plastic pipe does. So.
Okay, thank you.
Most importantly, though, I think we're keeping our options open until the time of actually awarding the bid. So there's as John mentioned, a competitive aspect to it. And then based off of that, we can, if they're relatively close and we think it's a better investment to do one over the other, then we can make that decision at the time
Excellent.
of bid award.
Perfect. Thank you.
Anybody else? Thank you, John.
Thank you, Joan.
Good afternoon, Commissioners. Chris Smith, R9 Property Superintendent, and I'll be providing an update on some of the recent activities and some of the things we've been working or will be working on this fall and winter. To lead off, I just kind of wanted to give you a brief update on the conditions of some of the native grasses. Some of the established native grasses, as you can see in this picture and the previous picture, are in excellent condition. Although the property is about 3 inches below normal rainfall for the year. From May through August, the property received 15.67 inches of rain. This is fairly significant because the rains were very timely, occurring during the warm season's primary growing season. Several of the pastures with a little bit poorer stands of native grass have seen some improvement. However, there are still some areas in need of overseeding and or herbicide applications. And we'll be looking to address that some next year. Invasive species management. There are a few invasive species out there. We have Johnson grass. We have some honey locust can be considered an invasive species, and sandhill plum thickets. And we have a few salt cedars along the river, all of which we'll be working to address as time moves on.
Hey man, sandhill plums are a state fruit, man. You
That's
can't be
exactly
calling
right.
them invasive.
Well, yeah, they're a native invasive. So this summer in spring we were working on starting to address the sandhill plums. We were able to treat the main roadways this year and began working on fence lines. Where possible, as shown on the picture on the right, we've been mowing overgrown fence line to create a buffer and to provide access for spraying and other maintenance. This fall and winter, we'll be working these areas to remove deadfalls and trees and maybe repair some fence lines. There are numerous locations that are difficult to address due to their locations and the slopes and the sand. We'll be addressing the more accessible areas first to prevent further encroachment and looking for ways to address the difficult locations. The picture on the left shows one of these difficult locations in which the fence is inundated with sandhill plums. The terrain is too hazardous to attempt to mow with our equipment due to, again, to the slopes and the sandy soil. I've been on a few of these a little bit, and it makes you a little bit nervous at times. Like, ooh, I better back out here. Road maintenance, road work completed early this year, held up very well throughout the summer. However, it's time to complete a little more work going into fall and winter. The picture on the right is of the north entrance after a 2.5 inch rain. It's probably 100 yards long, and I don't know how deep was that, foot deep in places. This was the worst of several locations. Work to create drainage. We did complete some work in these areas, particularly this one, but there's still a few areas that we need to address, and we'll work on that this winter as well. Property cleanup. Staff have made several trips to the local landfill. There are several locations with remnants of past operations on the property that need to be removed. We recently removed 2,500 feet of old irrigation pipe and took 2 truckloads of miscellaneous metal, wire, tires, and just garbage in general to the dump. But this is another item that we'll be working on throughout the fall and winter and probably next summer as well. R9 improvements this past year. This summer we constructed a 3/4 mile section of barbed wire fence to establish cross fencing between pastures 10 and 5. The new section of fence is shown here in red. It's actually pasture 10 and 11. That's what got me tripped up there. But we hope to bring this pasture into the rotational grazing plan once livestock water sources have been established. Right now, we have no water sources in that pasture. Maybe our tenant has applied for an EQIP grant, and so if he gets approved, we may be able to get some water sources in there. These 2 pastures have not been grazed. I don't know if they've ever been grazed. So they need some disturbance and some activity on them. This spring we had 2 livestock wells drilled in pasture 11, shown here on the right. The blue icons illustrate where the wells are located. We do not have solar pumping systems and stock tanks available yet on these as well. However, we hope to utilize this pasture in next year's grazing plan. We can maybe bring in some stock tanks, our tenant can, and a portable pump and start using those. Prescribed burning, we mentioned this in the spring update. We intend to carry out 2 prescribed burns this coming spring to increase plant vigor and reduce competition from undesirable species. We've been working with the Kansas Department of Wildlife and Parks to develop burn plans for 2 pastures in the southeast corner of the property, shown here in yellow. The same 2 pastures that we just spoke about with water and the fence line. The burn plans are nearly complete, but to carry out the prescribed burns, we will coordinate with the Kansas Department of Wildlife and Parks, who will assist the city by providing manpower, equipment, and their expertise. This will be entirely weather dependent. It's kind of a touchy situation, so the conditions have to be just right in order to carry it out. But we need to get some activity on that.
And how many
those 2
acres will be
pastures.
burned?
Huh?
How many acres will be burned?
The one is almost 1,000 acres, and the other is like 600 acres.
Wow.
So 2
Big-
pretty big pieces.
yeah.
We'll probably actually do it in 3 segments. We'll split that large pasture up. Walk-in hunting for 2024. We did renew and extend our WEHA contract with the Kansas Department of Wildlife and Parks. This year's contract will run from November 1st through May 31st, and will include the spring turkey season. The spring turkey season runs from the 2nd week in April through the end of May. Last year, our contract was up at the end of January, sorry. The R9 is located within Unit 4, which is a draw-only unit during the spring turkey season. And there are only around 350 permits available within the entire unit, half of which are reserved for landowners. Therefore, hunting pressure at the R9 should be somewhat minimal. However, those hunters fortunate enough to draw a Unit 4 permit and seek out the R9 should have a real quality experience out there. By extending the WEHA contract through May, the city will receive an additional $10,000 on this year's contract. So WEHA revenue will increase from $24,000 last year to $34,000 this year.
You know if there's any, or have you heard of any economic impact for their community with the walk-in hunting?
I have not. I plan on putting a couple kiosks out there, and I was wanting to go to the economic development if Kinsley has one. And
I
maybe
believe
a
they
list
do,
of
actually.
businesses and put them on there and talk to them about that. To try to steer recreationalists to the local businesses.
Yeah.
I think from a state level, they could actually produce some numbers based on averages
Yeah.
without having to have actual numbers,
Yeah.
which would be good.
Yep. This is voluntary public access program. This is a joint cooperative effort between Wildlife and Parks and the Natural Resources Conservation Service. They're working to establish long-term hunting access on private lands. This program is nearly identical to our current WEHA program. However, this program requires either a 10 or 15-year term. Payments per acre are higher, and full payments are made at the front end of the contract, not on an annual basis. So as a rough calculation for us, enrollment in a 10-year contract through this program would pay the city $544,000. The current WeHaul contract would be $340,000 for that same 10-year period on a year-by-year basis. So it sounds a little interesting. We'll be looking into this a little bit more this winter to see if this program would work with the upcoming well field development and construction, and determine if we want to commit to a longer-term contract. Conservation initiatives. It's kind of a big thing right now, it sounds like. There are several conservation programs available to landowners that are designed to compensate landowners for the protection of specific habitats, wildlife, agricultural practices, and even historical values. We'll be investigating a few of these opportunities for the R9 property, and the first of which are conservation easements. Conservation easements are voluntary agreements between landowners and a qualified organization, such as the Natural Resources Conservation Service or the Nature Conservancy. These types of agreements eliminate certain types of development rights on properties to protect the property's conservation values. The R9 property may be attractive to qualified organizations due to the current ranching practices and the native grasslands. For example, they may be interested in protecting the property's native grasses from being broken back out into cropping in the future. Conservation easement values are calculated by appraising the property as is, before any easement restrictions, and again after the easement restrictions have been negotiated. The difference is then paid to the landowner. Typically, sounds like the difference usually is in the range of 20 to 30% of the original appraisal. Conservation easements typically run in perpetuity, with the responsibility of managing the conservation values falling to the qualified organization. So if there was an issue, they need a prescribed burn or something like that, they would take care of it. The city wouldn't be responsible for it. Conservation banking is another hot topic right now. With the recent listing of the lesser prairie chicken as a threatened or endangered under the Endangered Species Act, a conservation bank specifically designed for lesser prairie chicken may be a good fit for the R9 property. The R9 property is located along the transition zone between the mixed and shortgrass ecoregions and lies in the middle of the lesser prairie chicken's historical range. Conservation banking establishes conservation credits on critical habitats. These credits can then be purchased to mitigate destruction of critical habitats in other locations that are the results of developments. A good example is wind farms. Conservation banking organizations work with the U.S. Fish and Wildlife Service to establish certified credits and to facilitate credit transactions for the landowner. This initiative also includes an easement on accredited acres, like the conservation easement, to guarantee against future development. These easements would run in perpetuity with the responsibility of easement enforcement and any land management needs falling to the banking organization. The city would be on the hook to maintain those properties. Currently, as credits are sold, 40% of revenue is paid to the landowner, 40% is paid to the banking organization, and 20% is paid into an interest-earning endowment that is established to provide long-term funding for any future conservation maintenance or management needs. And most recent prices I've been provided, or credits are selling for $2,500 an acre. So that's a pretty decent amount. Carbon sequestration. This is a little different one. Through the process of photosynthesis in plants, carbon dioxide is taken from the atmosphere and utilized for the development and growth of plant tissues. When the plant dies and decays, the plant material or carbon is then sequestered or locked in the soil. Carbon credit banking establishes carbon credits on these soils that can be purchased by industries with emission limits to offset the release of emissions above their caps. A carbon banker creates and sells the carbon credits to industries in need and pays for any additional management practices and soil sampling on the property. The landowner is paid by the banker for the carbon that is stored on the property, and 1 carbon credit is equal to 1 ton of carbon. From what I've come across so far, bankers are paying landowners in the range of $5 to $20 per carbon credit on agreements that range from 5 to 10 years. Healthy grasslands can sequester roughly 0.6 tons of carbon per acre. Therefore, the R9 and its rangeland might be attractive to a carbon credit banking organization. It doesn't look like the city would have to take any management actions at first glance. Soil samples would be taken with carbon amounts calculated and verified by a third party. The city then would be paid accordingly by the banking organization based on the tons per acre of stored carbon. All of these programs have potential for the city, but we will need to evaluate them against the development and construction that's going to be taking place on the property. I think there's a lot of potential, but our options may be somewhat limited, but we can work around a few of those things, I believe. To close, I just want to say that I appreciate the new modern security system on the right versus the old primitive system that had been in use on the left. The primitive system worked very well, however, it didn't discriminate between the good guys. So at this point, I'd be happy to take any questions.
This is really, really interesting. Not that yours wasn't good, John, but Chris's is really good. I really appreciate all of the avenues you're looking at for the possibility of revenue sources. That's really impressive. And carbon sequestration, I never heard the word
Yeah,
before.
I was kind of surprised too. I actually heard about that from a neighbor down there.
I'll be
And,
darned.
they have a program in place on one of their properties. It's a lot smaller piece of property, but it's something to look at.
Well, that was nice of them to come forward and help us out.
Oh, and on the carbon credit, blah blah blah, the conservation banking. Actually, there was a post, ironically, today Jeff came across that talked about the lesser prairie chicken and the potential of conservation banking. It's on Hayes
Oh,
Post,
yeah.
and that's one of the
Sorry.
that's the actual company that we've reached out to and spoken with this guy. So it might be of interest to you to check it out. You get a little more detail than what I can provide here.
Very
So,
good.
yeah.
Good stuff.
Very cool, and I just want to note that the previous primitive security system will still be there and in effect, even though you put a new one in.
Yeah, yeah. It's
That's
still there.
unfortunate. It's unfortunate.
Backup system now.
I like that backup system.
Thank you, Chris.
All right.
I think
Thank
we'll
you.
hear from city manager.
Toby Doherty, City Manager. I would like to give a brief update on the legal/regulatory environment that we're navigating our way through. So you may recall that in February of this year, the administrative law judge that served as a hearing officer in the transfer process approved the city's transfer application. The transfer panel then announced their intention to review the order. They did not set a hearing schedule, but they did set a briefing schedule on that. All briefs have been filed. During that time between when they set the briefing schedule, but before the panel that actually set a hearing schedule, our opponents, which are in this case Waterpack and Edwards County, they filed a motion that the chief engineer should recuse himself from the proceedings because they think he's biased, even though they provided no evidence of bias. So the hearing panel responded to that, and they denied the request. So Waterpeck and Edwards County filed a writ of mandamus with the Supreme Court, asking them to take it up. The Supreme Court, did they deny it, Don?
They denied it.
Yes, they denied it, and in denying it, they stated that Waterpack had other avenues to pursue, which was district court. So Waterpack and Edwards County then filed in district court for the chief engineer to recuse himself. There have been briefings filed in that. There was a hearing 3 weeks ago in the matter. The judge asked for 2 follow-up documents to be filed. Ours was filed last Friday. Waterpeck and Edwards County have until next Friday to file theirs. And then the judge said he was going to rule within 30 to 60 days after that last filing. He did say his intent was to rule very quickly in this matter. The hearing panel is on hold until the Riley County District Court judge weighs in on this. We do feel that the Riley County District Court judge is going to probably dismiss the case and rule the chief engineer doesn't need to recuse himself. So more on that probably next time we give you an update. You are aware of this, but for the public's knowledge, I would like to just let you know that yesterday a suit was filed in Edwards County in the 24th Kansas Judicial District The cities of Hayes and Russell are filing suit against the Edwards County Commission, the Edwards County Planning Commission, and a few others that were named in the suit for illegal zoning practices. I would like to give a little bit of a history of this before I get into some of the details of the suit. So the city of Hayes bought the property in 1995, and many of the same players with the Edwards County Commission, the Edwards County Planning Commission, and WaterPack were against, and very vocally against, the purchase back then. Did everything they could to try to stop the purchase of the ranch. Shortly after we purchased the ranch, the Edwards County Commission adopted essentially no development regulations for a very small geographic area that surrounded the ranch. A blatant violation of our property rights. A year later, that was replaced with zoning regulations that were adopted by the county. The zoning regulations in 1997 had an extensive set of regulations that dealt with water supply projects. And they seemed to be very concerned with water supply projects, and they put a conditional use process in the regulations to deal with water supply projects. The regulations as they were drafted and voted upon were blatantly targeted at Hayes and Russell, to the point where KDHE advised them that the regulations were not valid because they weren't legal or enforceable. So they removed part of a section of it, but the regulations have stood since 1997. So I would like to remember that, you guys to remember that Edwards County and WaterPack have been tied at the hip as our opponents. We talk a lot about WaterPack because I think they have been the driving force since day one. But since the beginning of the transfer proceedings, WaterPack and Edwards County have been tied together, represented by the same council. So all of the delays and the mistruths and the issues that the attorneys of our opponents caused are undone under the representation of WaterPack and Edwards County, and that's how they introduce themselves in every legal proceeding.
Now, you could almost understand the WaterPack and the radical methods they're going at. But the commission has a different responsibility, in my mind, to represent everyone fairly and to stay out of the fray.
As a governmental entity should, yes. So we had planned to legally challenge these zoning regulations. We knew this was going to be part of our legal path. It was just a matter of when is the right timing to challenge this. We needed to be far enough along in the proceedings and design to where we have the certainty of project before we challenge these legally. So to that end, we had originally planned on doing this summer or this fall sometime. It was discovered earlier this year that, I mentioned in February earlier this year, that the hearing officer approved our transfer application and approved it resoundingly. There was no question in the hearing officer's approval of the transfer application. In April of this year, the Edwards County Commission modified their zoning regulations. They adopted a new Article 24 that essentially creates their own version of the Water Transfer Act. So it takes an already difficult conditional use permit process targeted at water supply systems, and now they created their own mini version of the Water Transfer Act, except I would say it may even be more comprehensive than the Water Transfer Act. So that is the basis of why this suit was filed. So just a bit of legal input here. Zoning regulations can only be implemented to protect the public health, safety, and welfare. They can't be used to stop one project that a governing body doesn't like, or they can't be used as an end run around the Water Transfer Act, which is essentially what Edwards County is trying to do. The state owns and regulates all of the water in Kansas. Counties do not have authority to regulate water usage. Just like we don't have the authority to tell a water property right owner what to do with their water, that's the state that governs that. Cities also have broad statutory powers to own, operate, and maintain water supply systems outside their city limits and to deliver water to their residents. So this is why we feel that Edwards County's regulations are, one, they're an attempt to deprive Hayes and Russell of their property without due process, that we or their violation of the Fifth and Fourth Amendments. Their regulations are discriminatory, and they deprive Hayes and Russell their right to equal protection of the law. As I mentioned earlier, zoning regulations can only be used to protect the health, safety, and welfare of the residents. While Edwards County appears really concerned with the environmental and socioeconomic impacts of water supply projects, they failed to create regulations addressing feedlots, commercial dairies, poultry operations, hog farms, oil and gas operations, landfills, quarries and mining operations, facilities that manufacture and store explosives, and hazardous waste facilities. So I think we all understand why these regulations are very important to them. To me, it's a blatant abuse of the county's authority, and it's based on NIMBYism and basically a complete disregard for property rights and water law. So the suit that you have a copy of, we are asking for several things. We are asking the court to determine that the cities are immune and exempt from complying with the Edwards County zoning regulations. We are asking the court to determine that the Edwards County zoning regulations are void and unenforceable against the cities, that Edwards County is attempting to deny us equal protection and due process of the law, and that the cities are entitled to injunctive relief prohibiting the enforcement of the Edwards County zoning regulations. So this was a very large filing, and I will keep you up to date on the process as we move forward, and I would stand for any questions if you may have them.
Well, I think that, and being a part of this and following it and looking at the suit that you filed, really, the main thing was Edwards County didn't want any projects to detract, limit, restrict agricultural production in 1997. This project doesn't do any of those things. So in filing this Article 24, that's simply a pernicious, spiteful act that they're trying to do in order to give themselves unfettered discretion to deny anything that deals with water transfer and water production, which they really don't legally have to do. And they're doing this in spite of the fact that our project will not affect any of the surrounding uses by any of the surrounding landowners. It will not depreciate the value of their land. It doesn't affect public health, and it will not impair anybody else's surrounding property rights. And by reducing our water usage by 29%, it's not going to affect the water anyplace else. We'll use less water than what was being used agriculturally in that area. And despite doing all of that for them, and we've added hunting and conservation issues, which is going to bring people to that area. So we're bringing a benefit, and we're not detracting or impairing anything that goes on there. This is really a malicious, spiteful act, and it's just not legal, and I'm glad that we're taking steps to do something about it.
And I think it's important to note, too, that we're not upset at Edwards County, the citizens. We're upset at Edwards County, the governmental, arms that are setting these regulations specifically against projects like this project specifically. We didn't have to walk-in hunting. We did not have to do that. We did not have to lower ours by 29%. We weren't required to. We did that on our own because we wanted to be good stewards of the water and good neighbors. And I know we've had conversations, with many people in Edwards County, both, locally and at the governmental level, saying, like, what can we do to work together? We want to work past this and make things happen for the benefit of everybody. And it's just met with delay, and we don't want you to do this. And it's frustrating because we don't want to stop you from doing what you're doing. We want to be good neighbors and good stewards, and you don't have to set up local business places for them and work with their economic development. I think it's a great thing that you should, because that's what we want to do is help them, because it doesn't do anything for us if we don't help them out. But for us to be thrown under the bus for over 30 years, for not doing anything wrong, we're doing everything by the law, to the law, and beyond the law that we possibly could. And it's frustrating.
And the commission failing to engage with us in any way. How many times have we offered to talk to the commission for payment in lieu of taxes down in that county? We are totally ignored. No responses, no engagement. I don't know what else we can do.
Well, and when we offered in lieu of, the money for that, it wasn't to buy them off, it was to do the right thing.
Do the right thing.
To help them. And I've said over and over and over, as a business owner, I have many people from Kinsley that come to my store, and I think we should be good neighbors. But this is not about being good neighbors. We're just we bought the water, we own the water, we're giving up water that we have to do the right thing, and we're still beating our head against the wall. And I can speak for the residents of Hayes. We are sick and tired of waiting. I know, Toby, you said today you were in a meeting, you said we're being very patient. We're done being patient.
We're done.
We're done. I mean, we have to get this done.
I was going to add, I feel like their intent is malicious, is how it feels. And I mean, it's going to echo what's already been said, but we have been good neighbors. Some of the facts that Commissioner Barrick pointed out, we're also aiding in filling the aquifer by what we've done with the land. I agree. I don't know what more we can do to be a good neighbor and provide impact for them that's beneficial, and it feels malicious. So,
And we've never tried to strip the land of the water. We want this to be sustainable for Hayes and Russell and our area for many years to come. That's why we're doing what we're doing, and I don't know, it just blows my mind how they just continue. I mean, everything they do is just to delay it, and they think we're going to give up, and we're not going to give up.
We're not giving up.
We're the only ones that have committed to sustainability down there,
Yeah.
and nobody else is committed to sustainability. This boils down to optics. Some people don't like it, but optics aren't water law, and optics aren't state statutes. So we have a set of rules that we're governed under, and that's what we're going to operate.
Yeah.
I'm sorry if you don't like it.
And the reality is, we will deplete the water source less than the neighboring defendants that are in this suit are already depleting the aquifer. So, I mean, we're actually making it more sustainable for everyone down there, more than some of the residents that are named in this lawsuit are doing.
And we were able to do all of this without, the use of eminent domain or anything.
Right.
We acted as any private citizen would and went on the open market, bought it, did it right, did the research, hired companies that did all of this. I mean, and we've worked alongside them, showing like here's what it was when we had circle irrigation compared to what we're doing now with natural grazing and the grazing practices we have, and it just does not make sense to be villainized like this, and I don't understand what the reasoning is, because if they don't have the evidence to back it up, and we just continue to waste money on fighting unnecessary fights in court that they're losing at every corner because they don't have any truthful evidence to back it up, what's the point? What do they hope to get out of this aside from just hoping that we back out at some point? No, we've been doing this since before I was born. Now it's not going to stop now. It's not. It's going to finish, and it's going to happen now. Yeah, no. The R9 is going forward.
12, 13 years ago, I was asked to give testimony at a joint interim Senate House committee where they were discussing condemnation and condemnation as it related to water rights. And at that time, the biggest fear of the state ag organizations was that cities were going to start using their condemnation powers to acquire water rights. And we did do this correctly. We didn't use the power of condemnation to acquire water rights. It was acquired on the open market. I know there are people down there that think it's their water. It's not. It's the state's water. And when you have a water right, you have a right to put that water to a beneficial use, and that doesn't mean that water has to stay in the county. And that, I mean, newsflash, the water doesn't stay in the county now. It leaves in every bushel of corn and every head of livestock, it leaves. But this property was acquired and developed in the right way, and as you guys mentioned, we are the only ones that have reduced our usage. At the last R9 update, I showed a visual when we looked at the 51-year modeling of full utilization of the aquifer, which we won't use the full utilization for water right, we can't. But assuming we did for 51 years straight, we would cause the aquifer at our southeast border with our neighbor, who is one of the defendants in the suit, to drop by 0.2 feet. The aquifer itself will drop 11 feet, actually 11.4 feet. And yet somehow Waterpeck and Edwards County want to point to us as somehow causing impairment. Now, the reality is 140 feet of a saturated thickness exists there. So we feel after 51 years, 11 foot, that's a manageable decline. Water right holders are allowed to reduce the aquifers in a minimal amount. We feel that's minimal, but to have the people that are causing 11-foot decline and then the representative county government down there claim that we're somehow causing the problem with our 0.2 feet of decline, it's just hypocritical and laughable.
Well, it's just easy to go after, the unknown government entity that's coming into rural America and taking things, and you forget, we're not that far away. We're still rural America ourselves. We just happen to be 20,000 people who have been working nonstop day in and day out for decades now on conserving water more than anybody else in the state and in some other states. Of what we do day in and day out, of what our people do, watching their water usage just to make sure that we can do it correctly. And then when we have something that's sustainable, continue those practices. We're not going to give up. As soon as we get it, we're not just going to be like, oh, good, now we can all just run water in the street. It's not going to happen. We are committed to sustainability, and we've shown nothing short of being able to not be sustainable. We are going to continue that practice, and for them to insinuate otherwise is insulting.
I certainly hope the citizens of Edwards County are asking all the appropriate questions. I know if it were happening here, there would be questions asked.
And if not, ask us. We'll be glad to help them.
Absolutely.
Thank you.
Toby, that was very good. Thank you very much. Appreciate it. Commissioners?
I actually want to brag on our community a little bit. Many of you probably seen a post I put on Facebook last Friday, Oktoberfest. I had some customers coming to my store, 6:30, 7 o'clock at night, and they drove 11 hours, and I think it was Indiana. I'm not sure. They were going to Colorado, and they had planned, and I can't remember if they had been to Hayes before or not, but they had planned on staying in Hayes, because they had a long drive. And sitting there talking to them where they're from, and they said, yeah, we just drove 11 hours, and we're looking for a place, and there's nowhere to be found, and we're going to try and drive to Goodland, but you could just see by their eyes they were exhausted and stuff. And one thing in our positions, we all have numbers to people that maybe some people don't. And I text Adam Prey and Aaron Dreyer, said, hey, do you guys have anything? And I figured they didn't because it's Oktoberfest. And within 20 minutes, we had a room for them. And they just crazy busy. We were all probably partaking in Oktoberfest like everybody else, and they went out of their way to take care of these people. And I just, that's what we are in Hayes.
That's
and it
who we
just
are.
makes me so proud to be part of this community. And and actually Aaron had called back, but we had our phone on the bar, so we didn't see it. And Adam, right across the street, they didn't have to move the vehicle. Had an Airbnb there, and got them taken care of. And then I'd actually text them the next day, and they just got to Denver, and they said they were well rested and ready to see their family. So I thought that was pretty cool. And to those two guys to go out of their way to help them on one of the busiest weekends of the year in Hayes, I thought that was pretty cool.
Very cool. Commissioner Barrick?
Yes, I think echo that. We had, I think, a great Oktoberfest weekend. It was a great homecoming weekend. And we had lots of interesting visitors that through the town. We've had people at the museum from Texas and Indiana and Missouri and Idaho. So there's a lot of people and a lot of them were coming through to tour the area and came and stayed and visited Hayes and really appreciated what Hayes is and has to offer. So I think kudos again to everyone here, and I also just want to have kudos to everyone that's been working on the R9 project because it is that important, and everybody's been working their hardest and doing a really appropriate, thorough job and making sure that all of our I's are dotted and our T's are crossed.
Very good. Commissioner Cunningham?
Yeah, sorry, I had a couple thoughts going through my head there. I'll echo on a little bit of that in the sense that we have a great community, and I really do appreciate the fact when citizens are vocal and they want to continue to make things great here. So just keep doing that, keep letting all entities know what's important and what you want. And then my last little thing is we're to the end of the parade frenzy, so good luck to the Hayes High Indians tomorrow. I think they play Dodge City.
Mhm.
And yeah, good luck to the homecoming candidates.
Commissioner Reuter.
Yeah, I know we can get a little heated talking about R9 because we can only be so patient after 30-something years. Yeah. But it is such a phenomenal project that is going to have. I mean, it is going to be a world-changing situation once it's up and running. I mean, it is the make or break point in our history, and I think that's. I don't know what else to say besides it's pretty cool.
Hey, Commissioner Reuter, I had a customer tell me today that there's no way Hayes will ever grow any bigger. And I look at that, our water project, and I think they have no idea what we can be.
It's only just beginning.
That's why, that's pretty much what I said.
Yeah, we're growing huge. So a couple of weeks ago, huge, very large, very big, very large, very huge.
Carry on.
Yeah, there you go.
It's going to end. I promise you, this is right over here.
But the last couple weeks I had with TMP's homecoming. Obviously, at one point we had a large border program throughout our over 115-year history, and the amount of people who came back and they just said they left, they moved back where they're home from, Albuquerque, New Mexico, Hawaii, or anything like that. They go, Hayes just has that feeling of it hasn't changed, but everything's changing. You still have that same feeling. They're like, I could still go to the same, areas and still feel safe and connected, but everything's still keeping up with everything else that needs to happen, and it's growing. And they all kept saying how beautiful the community is. It's so clean. Everyone's so nice. And I remember it being so nice. And nobody ever believes me until they actually show up and do that. One gentleman and his wife came, and they live in Puerto Rico. And it's funny, he came as a border student, but every single one of their kids was born in Hayes, but they never settled in Hayes. So they would come, have their kids in Hayes, and then move off into different areas around the country or Puerto Rico. They go, we just liked Hayes for our kids to be born in, and then came back to Fort Hayes, and then they sent back off. But so it's super interesting to hear those stories, and it's highlighted again today. I got to sit down at Give Fest all day with a plethora of nonprofits from around the region, and the donors who allowed the fifth graders in our community to give $10 at their discretion to whatever charity they wanted. One little girl came up and she goes, "This is so hard. There's so many good ones. I don't know who to give my $10 to." And I was like, that is the essence of what Hayes is everybody's doing such a good job at what they're doing. Everybody's touching everybody's lives in some area that it's difficult to. I mean, might need a back brace how much we're patting ourselves on the back, but you know what? I think we deserve it.
Why not?
Our community is amazing, and I'm happy to be a part of it, and glad we get to do it together. That's all I got.
What can I add to that?
You can add a lot of things.
Thank you all. We're adjourned.
He's like, I got to work for a while now.